Good afternoon, everyone, and welcome to the Children's Commission's webinar series. Our new webinar is on filing for mandamus in child welfare proceedings, and we are very lucky to be joined by Justice Julie Countiss of the First Court of Appeals and Bill Connolly of Connolly, Schneider, and Shireman. And they are two vastly experienced experts on all appellate matters, and we're very happy to have them here to help us understand the mandamus process and how it relates to child welfare cases. So the first thing that I wanted to talk about was appealing a temporary order. So we know that most temporary orders cannot be appealed. And Justice Countiss, I might just ask you to explain a little bit about why temporary orders can't be interlocutory appealed, and sort of what is an interlocutory appeal and when does it apply?
Hi, everybody. Thanks for joining. So an appeal of an interlocutory order is appealing an order that does not dispose or resolve the entire controversy of the case. And the types of interlocutory orders that can immediately be appealed without having to wait for a final judgment in a case are basically enumerated by statute in the Civil Practice and Remedies Code, section 51.014. And that it's a fairly long list, but it does not include, generally speaking, does not include anything from the family code that I can see on the list. An example would be an order appointing a receiver, which I suppose could come up in a family law case. And in that event, you might be able to have an interlocutory appeal. But for the purposes of this webinar, with regard to child welfare law, most of the temporary orders that we're going to be talking about are not contained in the list of the statutory list of interlocutory orders that are entitled to an appeal before the case is resolved. Okay. Does that answer your question?
That does. Thank you very much, Justice Countiss. I just wanted to pause very quickly that I didn't make this announcement at the beginning of the webinar, but we will save some time for questions at the end. So if you do have questions as we go along, feel free to submit them through the question and answer function. Bill, there are some specific statutory authorizations to appeal temporary orders. One regarding the department's right to appeal the denial of a emergency removal under 262.112, and another statutory authorization where a relative or designated caregiver can appeal the denial of placement due to the conviction of a low-risk offense. Is there anything you want to share about kind of the process for appealing these two types of statutory designations where temporary orders can be appealed?
Yeah, good afternoon, and thanks for joining. So here's what I'd say. In a 262 or a CPS case involving children who are the subject of abuse and neglect allegations, the family code allows a judge presiding over this to enter temporary orders, including those under 105 of the family code. What I would say about 262.1112 is a parent is not likely to want to appeal an order in which the judge says you cannot remove a child. However, one parent might want to appeal a determination not to remove a child from another parent. The statute also authorizes an ad litem to appeal, which is involves another interesting question about standing, but that's not related to this subject or the mandamus. So it's three people that are designated, or three or four people that are designated in that statute when a court refuses. The other statute, the 264.754 statute, that a lot of times the department will say that they can't place a child with a relative or caregiver because they had a DWI 23 years ago. And it's CPS policy not to do that. So those people can appeal a determination, but a close read of that statute is that it's not an appellate remedy to the appellate court. It is an internal administrative remedy that the department is supposed to publish their protocols, procedures, and regulations related to that kind of a determination. So I think it's kind of a misnomer to say that it can be appealed to the Court of Appeals. I don't think the statutory authorization is there for that.
Justice Countiss, I'll go to you really quickly because I know the language, I think in 262.112 authorizes what it refers to as an expedited appeal. Is that any different than the accelerated appeal that we normally associate with child welfare cases?
Not that I can tell. We, frankly, I don't ever see these types of appeals. It doesn't mean they're not happening, but we certainly didn't find much in terms of a Westlaw search. But to answer your question, an expedited appeal is an accelerated appeal. So you would follow the rules and deadlines that are associated with any accelerated appeal, including filing your notice of appeal within 20 days of the order that you're complaining about being signed, for example.
Thank you, Justice Countiss.
I would note, Dylan, on this, there's, unlike a mandamus, there's nothing within that language that would suggest that the timeline in a CPS case could be halted while a temporary appeal or appeal of a temporary order is going on.
Correct. You're right. That's good to point out. And I mean, essentially, appealing, and this kind of goes to the first question you asked me earlier. Generally, interlocutory orders are not appealable unless something gives you permission to appeal them. And so this would be an example, obviously, of a time where the legislature is giving parties permission to appeal an interlocutory order. And by saying expedited, it's expecting them to follow the deadlines associated with an accelerated appeal. I don't have any idea why they don't use the word accelerated appeal. And there probably is a reason, but in this situation, they're the same.
What presents a little bit of a quandary is that they say expedited appeal, they don't say mandamus. And so we're not sure whether or not a mandamus would lie in one of these circumstances, but it doesn't preclude it as well. So I don't know.
Well, Bill, that's a perfect segue, because what we wanted to talk about next is, of course, mandamus. And so, Justice Countiss, I'll kind of turn it over to you. Can you tell us just a little bit about, what mandamus is and how is it different from the normal appellate process?
Well, I mean, as the slide says, a mandamus is used to correct a clear abuse of discretion when there is no adequate remedy by appeal. So, for example, to the question, the comments that we had earlier, if you have been given a right to have an interlocutory appeal of an order, you would not want to bring it as a mandamus because the standard is potentially higher to show that the trial court got it wrong. Because on mandamus, you have to show a clear abuse of discretion. So, that would be one reason why, if you can go under 262.112, then that's what you would need to do. But as far as mandamus goes, it's considered an emergency type of relief that you're seeking. It's an original proceeding. And I think there are probably a number of ways, and I'm sure we'll get into them in the webinar, that this could be used in child welfare cases. We don't frequently see it. And I don't have any explanation for why, but it's definitely an important tool in any litigator's toolbox. But in particular, when the trial court has made legal errors that are clearly wrong, and then having to see the case through under that legal error is going to harm you in some very clear and specific ways, such that you need immediate relief rather than having to wait until a direct appeal.
Bill, I was going to go to you next. Can you think of some specific examples of when someone clearly lacks an adequate remedy upon appeal that would, apply to these mandamus circumstances?
Sure. There are a number of circumstances. I can give you a couple of circumstances where I think it might apply, and I can give you some circumstances where the court held it didn't apply. So when you go to a 262-201 hearing, the department has to, consistent with the circumstances, prove that abuse and neglect is alleged to have occurred, that that reasonable efforts were made to prevent or eliminate the need for removal for the child from the home, and that reasonable efforts were made to allow the child to return home. I had a mandamus a few years back in which the department felt that the parents were responsible for the care of the child, and they proved what they thought to believe to be injury to the child. They had no evidence that either parent caused the injury. And when asked what efforts they made to prevent or eliminate the need for removal, they said none. And what efforts were made to return, they said none. And the appellate court said the department has to put on evidence sufficient to cover the three elements. When the judge granted the department conservatorship, the appellate court said that that's a clear abuse of discretion. If the evidence is not there to meet the elements required for removal, then you've abused the discretion because you haven't followed the law. And so that's one example where a mandamus would be an appropriate remedy. Another one we have discussed is the one related to competing constitutional rights. And there's no determination on this that I am aware of, but there's a dismissal statute that requires the department to try or dismiss within a year or lose jurisdiction within a year with one possible extension. But you have sometimes cases where parents are charged with a criminal offense, which is the same related conduct to the termination. And in those circumstances, when the criminal case has not yet gone to trial and the CPS case is mandated by statute to go to trial, and there's specific statutory instruction about this, you're forcing a parent to choose between two competing constitutional rights, the right to remain silent and the right to defend against a case involving a constitutionally protected parent-child relationship. So I think that's ripe for mandamus. I just don't I had one case where had it set up and the mandamus was filed, but the case got resolved by an agreed settlement. So, but I'm not aware of it, but I think it would be unconstitutional as applied to that particular parent under that particular circumstance.
So, Bill, I just want to summarize really quickly because we're talking about that sort of lack of adequate remedy on appeal. So you're saying in that first circumstance of the adversary hearing, the lack of adequate remedy on appeal is that to appeal the case, you have to wait till the final order for a termination trial, and you cannot correct the harm of having the child removed. And in the second example you gave, the person would have to testify in a civil case and essentially testify about matters and put testimony on the record that may subject to them to jeopardy in their criminal case. That in those two circumstances, that's why the normal appellate process does not provide relief.
Yeah, you can't unpack the latter one. You can't unpack it. You can't put the testimony back in the bag and protect it. In the first instance, you have ongoing medical treatment of a child that a parent disputes. You have injuries that medical records suggested were not caused by abuse or neglect. Those were, of course, disputed fact issues, which is another issue you have with respect to mandamus. But a parent being deprived of custody and parental rights, powers, and duties for a period of 6 to 9 months, when the statutory elements are not met, there's no adequate remedy for that.
Well, I wanted to move on a little bit and talk about sort of the standard of review, which we talked about is abuse of discretion. And I might go to you, Justice Countiss. Can you talk a little bit about like what the abuse of discretion standard means?
Well, it's the, it's obviously one of the most important parts of your mandamus. What it means for us is that there's been a significant legal error made by the trial court. And it's important to emphasize that whatever legal error you are arguing to us in your mandamus, it needs to be clear that that is exactly what was in front of the trial court that you're arguing they got wrong. You'd be surprised. We see a fair amount of mandamuses in other civil types of cases where the error they're complaining about, it's not that it didn't happen, but it may not have been in the way that they're describing it, or they've, with hindsight, been able to add more details to their argument. But when we look at whether it's a transcript or a motion with a signed order, the issue that they're really trying to get mandamus on, it's not clear that it was teed up for the trial court to decide or not. And so, I mean, it's a simple thing. If we can't mandamus a trial court judge about something that it's not clear they did or didn't do. I know that might be obvious, but having been an advocate for a long time, I do know it's very easy to be caught up in your case and what's right and what's wrong and what's happening in the case. But we're looking at it cold, and so especially for an original proceeding, a mandamus, it really has to be spelled. The abuse of discretion really has to be spelled out, very clearly. And there have been plenty of times when, I'm thinking to myself, wow, I don't think I would have done that. I don't think I would have granted that motion to compel such a wide amount of discovery or, something along those lines. But it's not an abuse of discretion. That trial judge just had, used their discretion a little bit differently, but they haven't actually gone outside, guiding rules and principles. And in those situations, it's not for me, as the rule and the case law says, to substitute, my judgment. And same with, let's say, for example, temporary orders. The facts that are found by the trial court, as long as they're supported by the record, I don't have, that's not an area that appellate court judges are allowed to change. And so if the facts are supported by the record, it could be that I read those facts and I don't necessarily think it means that the parents are endangering, but the trial court does. And as long as there's wiggle room in there for somebody to decide either way based on those facts, I would have to defer to the trial court's, factual determinations, as long as they're supported by the record. I think a really good advocate can make really strong arguments for, even if the facts aren't necessarily disputed, for maybe harm that's done by the way that the trial court interpreted those facts. So as much as mandamus has these black and white rules, frankly, there is a lot of wiggle room for how to argue it. It just has to really have solid support in your record.
Thank you, Justice Countiss. I want to follow up just very quickly. How does the appellate court treat the factual determinations by the trial court and mandamus proceedings?
Well, we defer to those. Again, I mean, we are not the fact finder. The trial court is the fact finder. So if your mandamus is all about disputed facts and your facts are right and their facts are wrong, that's typically not going to be within our within our power. These are legal questions. You're telling us that the judge got a legal question wrong. And, because we don't see very many of these at the moment on temporary orders, it makes it a little harder for me to, Bill will be better at, at posing, I think, hypotheticals. But, if a trial court issues temporary orders and they are just clearly not supported by the record, or they go so far much farther than what the facts established, then sure, that's getting into, an abuse of discretion potentially. But I don't really know. I don't have any other better way to say it, just that we're not the fact finder. And so as long as the facts are supported generally by the record, even if there's disagreement, that's not something I can disturb.
Yeah, Bill, I might just kind of go back to what you mentioned earlier about that case where the testimony of the caseworker was that no reasonable efforts were made and there was no attempt to return the child to the parent. And that seems to kind of meet this definition of abuse of discretion, because there was clearly a statutory element, and the testimony was that there was no compliance with that statutory element. And Justice Countiss, if I hear you correctly, what you're saying is if there was testimony of some sort of efforts that were made, then you as the appellate court have to sort of defer to what the trial court interpreted those efforts as. Am I getting that right?
Yes. Mm-hmm.
Yeah, I think that's a fair response. Yeah.
So I now want to move on to some specific circumstances where mandamus is authorized by statute. And one of them is under Texas Family Code 109-001A, and that allows a court to make any necessary orders to preserve and protect the safety and welfare of a child pending an appeal. And those orders can be challenged by mandamus. Justice Countiss, have you seen any of these cases? Is this something that comes up for you?
I cannot, I mean, sitting here, I don't recall a mandamus in this area. It doesn't mean, again, that they're not happening, but it's certainly not in some sort of high volume that, where we're talking about them over here. Okay. I think we definitely get issues related to this raised in direct appeals often, and most of the time, by that point, it's a moot issue. But yeah, I don't see mandamuses.
Bill, can you think of a circumstance where a mandamus in this sort of statutory scheme might arise in a child welfare case?
I could, but I would agree with Justice Countiss. It's going to be a rare circumstance in a CPS case or a child welfare case that this would arise. One idea that I would have is where the department and the ad litem are aligned and they agree, and the court orders termination of the parent-child relationship, orders the department to be managing conservator. And the parent files an appeal and requests some temporary orders pending appeal. And the trial court then makes intrusions upon the rights, powers, and duties of either the department or a designated conservator, allows parental access and possession to continue post-termination. There'd be a number of temporary orders that a trial court could do that sort of fly in the face of what a termination order actually means. And so I do see there's the possibility of that. And if they were so egregious, they might authorize a mandamus. But I've never actually raised one nor seen one in any of the appellate opinions that I've read.
And I just want to add, because as we prepared for this webinar and then as it's happening, of course, I'm thinking of more, I guess, details about this whole issue. But, I would assume that mostly why we don't get a lot of mandamuses in situations, related to trial court orders that deal with the safety of a child, is because those are going to be extremely fact intensive. And again, absent a trial judge who's just ignoring the facts completely or making up their own facts or something, weird is going on, it would be hard for me to imagine a situation where I would say, no, you're wrong. There's not any danger there. That's just not really our role. But I do want to add that, and again, I have not practiced as as a lawyer in this area. And so, sometimes I don't, I don't have the terms of art down, but I would keep in mind that if you go to if you're in whatever kinds of hearings we're talking about that are resulting in trial court orders in a child welfare case, a lot of times it seems to me that all the folks who are part of this case, including the trial judge, they all know all the facts and the details because it's in various documents and affidavits and maybe sometimes by testimony. But that doesn't necessarily mean that all of that was in front of the judge as admitted evidence when they were making certain decisions. So I would just argue that even if everyone, both parties and lawyers and the judge all, I can't think of a hypothetical because I don't, maybe they all know something really bad about the father, because it's in some documents somewhere. But for whatever reason, it wasn't necessarily put forward as evidence to support, a decision that's made. I just think this is an area of law that I think is fascinating because I think I see it on a direct appeal sometimes where there are rulings made that it turns out that evidence or that document actually wasn't admitted. It wasn't an exhibit, like at final trial, for example. And I don't know that that somebody forgot. I just think everyone gets so invested in these cases and is so familiar with, with what's happening, and they're in front of the trial judge so frequently that sometimes the nuts and bolts get blurry a little bit. So I know I sound like I'm babbling, but it's because I'm not trying to encourage mandamus, but I'm just saying, if you get a decision that you think is wrong, go back and really look at what was in front of the judge validly under the rules when that decision was made, because it's possible that there wasn't enough.
Thank you, Justice Countiss. I think that's a great point. I wanted to kind of very briefly cover two of the other statutory authorizations for mandamus. The second was authorization that if a court fails to set a final hearing and a date that permits the court to render a final order before the statutory hearing date, any party or the child's attorney can seek a writ of mandamus to compel the court to hold a trial during that time. I don't have a lot to say about this, but Bill, I was wondering if there's anything that you wanted to add or comment about, why this provision is there.
I didn't mean to seem impolite, but I was laughing when Justice Countiss was talking about direct appeal, just since my pet peeve about the absence of proper evidence of points of error in trial court proceedings. I don't see a parent necessarily wanting to mandamus a court to set a timely trial. I think they'd rather have the court lose jurisdiction. But I see the point of allowing for a mandamus if the court, for whatever reason, a Maverick court is refusing to conduct a trial within the time frame or find extraordinary circumstances to do an extension and de facto sort of creating a loss of jurisdiction. I can see where somebody would want to pursue a mandamus, and I can see why the legislature, it seems like it's probably a case specific or a few case specific reasons why the legislature enacted that. The second or the third one there is a more interesting one because it requires the court, once it commences trial, and this is I think a statutory remedy for the fake trials, for the court calling the case to trial, somebody asking the caseworker their name and that they're assigned to the case and nothing substantive happens, and then the case gets reset for 18 months or something like that, and trial never concludes. And so to address that, the legislature passed this law that says you have to render an order within 90 days unless timely extended. They don't define what timely extended essentially means there, but at least when you're looking at this code provision, a party can file mandamus to compel the judge to actually render an order within the time required. So I don't know what time frame that means. If you're at day 60, and the judge still has 30 days to render, do you file a mandamus? Because you can't file after the 90 days because you want the judge to render an order within the statutory time frame. What it doesn't say is whether or not that's jurisdictional.
Mhm.
It refers back to 263-401 and the commencement of trial. And I think that it's not jurisdictional. And I think the reason it's not jurisdictional is that the loss of jurisdiction happens when you don't start a trial. So I don't think that this would be a jurisdictional error. It would require a mandamus, but I think if somebody were to file a mandamus and the judge were to ignore this statutory requirement, pretty pro forma, I think the Court of Appeals probably would say you need to enter a final order, but I don't know.
I mean, this all falls under I think it's interesting that these are statutory authorizations because to me, this really all falls under the failure to perform a ministerial duty in sort of a general way, which is one of the more common reasons for granting mandamus in other types of cases. So I would say, to Bill's point about, how long is long enough, how many months or, what is the, how long do they have to have failed to render a final order or how long do they have to have, delayed setting the final hearing? You might do some research on other civil cases where a mandamus was granted for a judge not signing a summary judgment order that we have a lot of those where, a judge has granted or denied, summary judgment and on the record, but the order, isn't signed, or a final judgment not getting signed. There's case law out there, mandamus case law on kind of how long is too long. What's an unreasonable amount of time? So, I would just say that would be maybe a touchstone because there's plenty of case law in that.
We saw this, I think, somewhat more frequently in the family law arena. We had a judge in Harris County, no longer a judge, who would sit on orders for a year.
Yeah.
And the whole community estate would change during the year's pendency, and all of the findings would no longer be valid. So you need to have a timely remedy, a way to get this resolved. In CPS cases, because we're dealing with abuse and neglect, and we're dealing with permanency needs, it's even more compelling to get a timely order.
Thank you, Bill. So I wanted to move on to sort of the next topic that we wanted to discuss today, and that's sort of case law precedents for mandamus. So these are circumstances where mandamus has not been specifically authorized by statute, but where courts have found that mandamus is appropriate in child welfare cases. And the first instance that comes up is, of course, the adversary hearing. And several courts have ruled that a court's decision to allow DFPS to maintain custody of a child following an adversary hearing is reviewable by a petition of mandamus. Bill, I might start with you. Are there any specific examples of when an adversary hearing has been mandamus that you think attorneys should be aware of?
Well, I will say this, in your regular research, you're not going to find a lot of the mandamus opinions when you're searching for these things. So I've compiled this list of a number of mandamus proceedings in which mandamuses were granted. The Steed case, of course, is the 468 children involved in the Latter-day Saints case out in Central West Texas. And, the court says if you don't meet the standard of proving harm, then you can't keep conservatorship. It doesn't necessarily kill the case, or remove the department from seeking relief on behalf of kids. And I think out of 468, they said that it was valid as to 20 or 30 of them. But these are a number of different cases that are, I think, quite interesting. Tamika Henderson was a case with questionable evidence about a mental health history. Cochran is an interesting case where mom had lost 9 different children by termination, but there was no evidence to say this new child was endangered in any way. And so you didn't meet the burden to have custody of this child. So there are a number of reasons why the department, I have other cases as well. The one I referred to where they didn't prove the element, the 2 elements. So there's a lot of reasons. Here's what I'll say about adversary hearings and these decisions. The pertinent phrase within this slide is, if at all. If you have a decision where the trial court clearly abused its discretion, did not follow the law, gave the department managing conservatorship, and you do not seek relief by mandamus, your temporary orders are going to be either established as a matter of law of the case by the time you're through. Your temporary orders are going to be subsumed within the final decree, and your appellate remedy is going to be no longer existing. You cannot seek relief for one of these kinds of violations of a court order unless you do it expeditiously, unless you do it right away, or you're going to lose the ability to make that complaint on appeal. I can't stress that enough.
Mm-hmm.
Justice Countiss, I might look to you and say, like, what does a party need to do to prevail on a mandamus of an adversary hearing order? Because I do think it's important to keep in mind that both, the department has the option of mandamusing, as does, party or even the child's attorney. So can you talk just a little bit about that, about what you think what a party needs to do to prevail on an adversary hearing mandamus?
Well, I think earlier in the slides, there was reference to a 14th Court of Appeals case from 2017, in re MNM. And that might be one, and I don't have the site in front of me, but I'm almost certain it was in an earlier slide about mandamus, because that's where I got it from. But it's a situation where the Court of Appeals held that the record did not establish an urgent need for protection that required immediate removal of the child from the parent's custody. So, I mean, for starters, that might be a good case to look at, especially since it's not terribly old, for, how to be successful on a petition for writ of mandamus in this subject area. But I would say, it's just going to be important to clearly argue both prongs of mandamus, that an abuse of discretion has occurred, and that you do not have an adequate remedy at law or adequate remedy by appeal, are the 2 different ways to say it. And I think, it's pretty clear that's very possible that you could be successful, because, like what Bill said earlier, most of what's happening in the temporary orders is not going to be something you're appealing on direct appeal, because they're going to have already been, it's going to be moot. But they could be, extremely important to the case and to the, either the children, to the family, to the permanency, to, a lot of different things. So in terms of showing the appellate court prevailing on those 2 elements, I mean, I don't know, I think later in here we talk more about the actual process, but I'm going to need to see what was the trial court basing their decision on. So, do you have testimony? Do you have, is it the affidavit? Is it, and is it all in properly? If there's a transcript, which ideally there will be, and keep in mind, you can, a party could file a mandamus. And I'm sure everyone's thinking, well, how the heck am I supposed to get a transcript from a hearing that quickly? You can file your petition and give all the detail, and you can supplement. And you can set, you can, I mean, we prefer to have everything as quickly as possible, but if you're concerned that it might look like you're delaying or anything like that, you can file your petition with everything that you do have. And then if there are other elements of the record that you don't have yet, or that aren't ready, you can supplement your record, and you can supplement your mandamus petition. And I would just explain that in your petition, because I think this is a subject area where there's a lot of moving parts, and if you do have the need to get immediate relief, you're going to want to be moving pretty quickly. And I would argue waiting, letting the results of the adversary hearing go into effect for several months before deciding to address it in a mandamus is probably not going to be very helpful. Because delay can sometimes be a reason that we would not grant a mandamus. Again, these are emergency writs. And so we really need to see the emergency. And we'll get into the nuts and bolts a little bit about what has to be included later, I think. But yeah, mostly. And this might be a time to also, I know I think a lot of people have heard me say this multiple times, but in other venues, but the trial court taking judicial notice of the file does not generally mean a whole lot. And so I don't see it as much as I did 5 years ago when I first came to the court. I don't really know if it's because I don't know whether that's because of changes in judges or what, but yeah, I mean, if in trial court, that's not evidence. So just make sure whichever party you are, whichever argument you're making, that you're not relying on just what's in the file that everybody knows is in the file, but hasn't actually been presented as evidence to support your arguments.
Let me give you a very concrete example of the importance of what Justice Countiss just said. In the case involving the conservatorship where they didn't prove the two elements, we had a 3-day adversary hearing, about 6,000 pages of medical records. And no way on a mandamus proceeding are we going to have that reporter's record available right away. But when the court orders the department to be managing conservator, and there's no proof of the elements, you can get excerpts from a court reporter of the specific testimony to support your mandamus while the record is being prepared. And in certain circumstances, when the department is geared up to make life-challenging medical decisions, invasive medical procedures, when there is no proof on the statutory elements, you can't allow the department to engage in hyperextensive medical procedures without challenging it. So you have to move quickly.
Thank you, Bill. I want to move on to other aspects of an adversary hearing that have been subject to mandamus, particularly regarding timing. And Bill, do you want to talk a little bit about when a court can be mandamus to hold an adversary hearing?
So there are circumstances in which parties go to the judge and they're set for, they get emergency hearing order, and then they go for an adversary hearing order, and the lawyers for the parents get appointed the day before the hearing. They have no time to prepare. So they ask for an extension, and you can get an extension, but it's limited. And then the parties want to go to mediation or whatever. So you can agree to extensions of emergency temporary orders. This is a circumstance where the court doesn't hold an adversary hearing over the objection of a parent. And you can seek relief by mandamus. Two interesting points here. One is, in fact, I know it's not jurisdictional. So the court doesn't lose jurisdiction by virtue of not having the adversary hearing within the statutory time frame. But the other, I think, more interesting point is when the court holds an adversary hearing and you have an absent parent, or the biological mom doesn't disclose right away who the actual dad is. I think the dad has a statutory right and a right under Stanley versus Illinois to an adversary hearing when the dad gets brought into the case, regardless of how far into the case you are. And I think if the judge denies that right to an adversary hearing on that parent seeking relief, that's subject to mandamus. And I think that parent would have the right to say to the appellate court, I'm not getting my adversary hearing, and I'm entitled to one.
Justice Countiss, I might go to you, and this applies, I think, to this, but also that circumstance we talked about a little bit earlier, that statutory authorization to compel a court to hold a trial before the deadline. Are there any circumstances that attorneys should be aware of when you're mandamusing the lack of action by a court rather than, mandamusing the decision that was made by a court?
Right. We get failure to rule type mandamuses from other types of practice areas. And so, rather than here's an order that the judge signed and here's why it's all wrong, it's kind of the opposite. We can't get them to set this or to sign this. So you just have to figure out how to show us that. So it could be, it obviously could be, it could be a docket sheet. I mean, docket sheets are not, this is where we kind of have to throw everything at it. But whatever it is that you have that tells you as the lawyer that the judge has not set this yet is what we would need to see. It probably needs to be more than just telling us in the petition. There are times when when one of our staff lawyers will actually go and check the trial court, go online in a mandamus situation and check the trial court's, check the case on the district clerk's website. If it's unclear to us, and it doesn't necessarily mean I'm not saying that it's because we're going to do it for you. It's kind of the opposite. We've had situations where like it might be a discovery dispute where they've made this big argument about why this discovery is problematic and how it's going to hurt them timing wise with trial, but they never really get clear about when trial is and why. And we might go and check on the website and see, something completely different than what they're presenting. So I would argue that in this type of case, whatever docket control order or whatever it is that you guys refer to see if something's been said or not, it is kind of what you're going to have. And then if you have, I don't know how, I know Bill mentioned so you would object, I guess, to the trial court's failure. One side would object to the trial court's failure to timely hold the adversary hearing. Is that correct?
I think you would need to file a motion.
Right. I was going to say there needs to be something else in addition to showing us maybe just from a, process point of view, an opportunity for the judge to be clearly made aware that, hey, this is an abuse of discretion. You may not say it that way. And give that trial court an opportunity to do it correctly before you can come and ask me to rule that this trial judge is, abusing their discretion.
So not merely a lack of action by the court, but documenting in a motion or some other form the opportunity for the court to act that they have failed to act.
Yeah, not just we called the clerk's office 5 times and the court coordinator said the judge is, too busy to set it. I mean, you can put that in your motion. There's nothing wrong with that, but you're going to need, it's really going to be better if you can have something a little more concrete.
I think you have to show the appellate court that, like in any error preservation on a direct appeal, you have to show the appellate court that you made an earnest attempt to get the court to comply with the statutory requirements, and the court either denied it or just refused to do it.
All right. So thank you both so much. I want to just move on very quickly to other circumstances that courts have found can be mandamus in CPS cases? And Justice Countiss, can you kind of help us go through just these three very quickly?
I mean, I've looked at all these. I don't really know that I have a lot to add, just that I think we've kind of already talked a little bit. I mean, the first one, mandamus to compel the trial courts to dismiss a suit for failing to comply with the statutory dismissal deadline. That's similar to what we were talking about in terms of not setting something timely. So again, you'd want to make sure we have a complete record, because when you file a petition for a writ of mandamus, you're typically not getting the district clerk's office to send us a record. Sometimes, but a lot of times when you initially file it, you're going to be providing us the documents, and they're going to have to be certified and sworn to. But you want to make sure that you're giving us everything that's necessary to show that the trial court was given the opportunity to dismiss the suit, and they haven't. And then the legal reasons why that could be a mandamus. Same with the termination, not hold termination trial on holy days. I mean, it seems like there's case law there. So if you have a judge who's asking you to come to court on a holy day, and there's clearly case law that says that that's not okay, then that, you would want to provide the documentation and cite to that case. And I don't know, I honestly think I don't know a lot about orders in aid of investigation, but I mean, I'm assuming medical related orders, maybe education record related orders. I don't know, that would maybe be Bill who would be able to speak to that a little more. I haven't seen mandamuses on this.
Well, I want to move on because we've got some questions coming in, and we are running close on time. There's a few more things I wanted to get to. So I wanted to move very quickly to discussing about how the right to mandamus is not absolute. Justice Countiss, what are some circumstances where a court would use its discretion to deny a mandamus request, even though the mandamus request may have met some of the elements we talked about, but a court would still deny that mandamus?
Right. Well, I mean, you have to show both elements, period. Even if I can tell by looking at it that that there was an abuse of discretion, or that you probably don't have an adequate remedy by appeal, those arguments have to be made to us. We can't make those arguments for you. And it's particularly on the second element, we get a lot of, well, there's no adequate remedy on appeal because if we have to wait to get this decided, it's just going to waste time and resources. We get that a lot, and that's really not enough. And I don't know that, I think in the context of child welfare, you probably have a mountain of reasons to provide for why a delay, why you can't wait, why there isn't an adequate remedy on appeal. And it may simply be because the temporary orders will be moot if you have to wait for an appeal, a direct appeal, or it may be something very specific about the child or the parent or the family involved in this case. It could be something mental health related. It could be something physical health related, some sort of important decision that is impacted by the temporary orders. But you just need to make sure that is explained in the second element of a mandamus. And then another common reason that we deny mandamuses is for not providing us an adequate record. And that could just mean that either you don't provide a record at all, you provide a record but it's not sworn to, or it's not verified properly, which is all explained in the rules, or you provide a partial record. So maybe you provided the motion that you filed that you're claiming the judge erroneously denied, but you don't give us a trial court order. So if we don't have anything that establishes that the judge actually ruled the way you said they rule, we just have to deny it. And we're not required to write opinions on a denial. And so a lot of times it's just going to be, it's just going to be a denial, and you may be wondering why. But Texas Rule of Appellate Procedure 52, and 52 generally has a list. It's like a recipe. Do this, 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 this. And so we really do. That's very firmly enforced.
Well, thank you, Justice Countiss. That's the perfect segment to our last section, which is regarding the process of mandamus. And as you said, the process of mandamus is governed by Texas Rule of Appellate Procedure 52, and that describes all the procedural requirements for petitions for mandamus and other original proceedings in appellate courts. I highlighted there's several different subsections of 52, but there are three that I wanted to highlight here to see if you wanted to talk about them a little bit. And it's the form and content that needs to be in the petition, the access of and providing the record, and then requests for temporary relief. And Bill, I'll go to you first. Is there anything that stands out to you about the process of filing mandamus that you want to make sure people are aware of?
Well, I'd say first and foremost, make sure that you have sufficient record to the court so that the court can actually grapple with the issue or issues that you're presenting. The form and the contents of the petition are going to be particular to the circumstances of your case. But when Justice Countiss was saying that you need to have the record sworn to, the lawyers actually swear to the record.
Right.
The lawyers file affidavits certifying that this is the court reporter's record for the particular hearing. These are the documents and pleadings on file. So you don't have to wait for the district clerk to prepare in the post-judgment section to prepare your record for you. You can get it to the court very, very quickly. The motion for temporary relief is when you have not only a clear violation of the law or an abuse of discretion by not following the law and a lack of remedy by appeal, adequate remedy by appeal, then you need to ask the court for some temporary relief. If the court grants CPS conservatorship at an adversary hearing and the elements of the statute haven't been met, you're going to need to try and get the court to stop the proceedings and stop the authority of the department to do those things as a parent's right, power, and duty that a parent has that they want to protect and preserve. You got to get that to the court right away, because if you wait too long, as you go back to the last slide, you're losing your leverage. You're losing the urgency of the case.
Justice Countiss, is there anything you wanted to add kind of regarding the process of the appeal under Texas Rule of Appellate Procedure 52?
Well, just not delaying. Again, if you're asking us for this type of relief, I mean, I certainly know that not everybody can, file it the day that the judge made whatever decision you're complaining about. But, waiting till the last minute, and especially in the context of child welfare cases, I mean, if you're right up against final trial, I'm not saying, I'm not saying don't file it and that there wouldn't be situations where you would still want to, but, just make sure that you're doing this timely. And if you're filing a motion for temporary relief, which for us, I think would be like an emergency motion to stay, be really clear why it's an emergency. That may sound obvious, but the more you can give us, the better. And also, I just thought of something else a second ago. With regard to the record and the form and the contents, I mean, if there is some reason why you've had to delay filing your petition, or there's some sort of delay with the record, just explain that in your petition. I mean, there's a lot of rules with mandamuses, but at the same time, there is also a lot of wiggle room, back and forth for you to really, go overboard in explaining to us, what's going on and what the problem is. And, especially in child welfare, you guys are dealing with a lot of moving parts and a lot of, human condition. And you may have some really compelling facts for why something needs to happen or doesn't need to happen right away. So just get those really in front of us.
Thank you so much, Justice Countiss, and thank you so much, Bill, for a wonderful presentation. We are at time, so I want to thank all of our panelists and all of our viewers today. I want to thank people who submitted questions. Unfortunately, we did not have time to get to them. This webcast will be archived and it will be available on the Children's Commission website. For those of you who may be in the future watching the archive version, you can email the CC, the Children's Commission training email box for the MCLE information. For those, I want to thank everyone for a great presentation. We will have our next webinar. Will be on handling your first child welfare appeal. That will be in June. We don't have a date set yet, but we should be sending an announcement about the date soon. Thank you, everyone, and I wish you a great rest of your day.